You are responsible for your debts. If you fall behind in paying your creditors or if an error is made on your account, you may be contacted by a debt collector. A debt collector is any person other than the creditor who regularly collects debts owed to others, including lawyers who collect debts on a regular basis. You have the right to be treated fairly by debt collectors. The Fair Debt Collection Practices Act, or FDCPA, applies to personal, family, and household debts. This includes the money you owe for the purchase of a car, for medical care, or for charge accounts. The FDCPA prohibits debt collectors from engaging in unfair, deceptive, or abusive practices while collecting these debts. Under the Fair Debt Collection Practices Act, debt collectors may contact you only between 8 a.m. and 9 p.m. Debt collectors may not contact you at work if they know your employer disapproves. Debt collectors may not harass, oppress, or abuse you. Debt collectors may not lie when collecting debts, such as falsely implying that you have committed a crime. Debt collectors must identify themselves to you on the phone. Debt collectors must stop contacting you if you ask them to do so in writing. Have you ever been billed for merchandise you returned or never received? Has your credit card company ever charged you twice for the same item or failed to credit a payment to your account? While frustrating, these errors can be corrected. It takes a little patience and knowledge of the dispute settlement procedures provided by the Fair Credit Billing Act, or FCBA. The law applies to open-end credit accounts, such as credit cards, and revolving charge accounts, such as department store accounts. It does not cover installment contracts, loans, or extensions of credit you repay on a fixed schedule. Consumers often buy cars, furniture, and major appliances on an installment basis and repay personal loans in installments as well. What types of disputes are covered? Well, the FCBA settlement procedures apply only to disputes about billing errors. For example, unauthorized charges. Federal law limits your responsibility for unauthorized charges to $50. To take advantage of the law's consumer protections, you must write to the creditor at the address given for billing inquiries, not the address for sending your payments, and include your name, address, account number, and a description of the billing error. Send your letter so that it reaches the creditor within 60 days after the first bill containing the error was mailed to you. Send your letter by certified mail, return receipt requested, so you have proof of what the creditor received. Include copies, not the originals, of sales slips and other documents that support your position. Keep a copy of your dispute letter, too. The creditor must acknowledge your complaint in writing within 30 days after receiving it, unless the problem has been resolved. The creditor must resolve the dispute within 2 billing cycles, but not more than 90 days after receiving your letter. While your bill is still in dispute, you may withhold payment on the disputed amount and related charges during the investigation. You must pay any part of the bill not in question. The creditor may not take any legal or other action to collect the disputed amount and related charges during the investigation. While your account cannot be closed or restricted, the dispute amount may be applied against your credit limit. You can sue a creditor who violates the FCBA. If you win, you may be awarded damages, plus twice the amount of any finance charge as long as it's between $100 and $1,000.